Okay, so let's get started. Okay, so one question that we have is, can a J1 waiver be obtained if there's no employer sponsorship? Well, there's programs such as the Conrad 30 program that does require employer sponsorship, but other types of J1 waivers, such as a hardship waiver, or persecution waiver, or no objection waiver, does not require employer sponsorship. The Conrad 30 waiver is for physicians, as well as the VA waivers for physicians. But the other waivers that I mentioned don't require an employer. You can file that without an employer. All right, let's move on to another question. What is an I601 waiver for? Well, I601 waiver is basically overcoming a ground of inadmissibility. So that could be, for instance, for a crime of moral turpitude or different types of crimes. That could be also for fraud or misrepresentation. For instance, if you got a visa denied before because of misrepresentation, we've done I601 waivers in those situations. So if you look at the 485, and there's a lot of questions on the 485, and those questions have to do whether or not you're admissible or not admissible. So the I-601 waiver can overcome some of the grounds of inadmissibility on there. Another ground of inadmissibility is the 10-year bar or 3-year bar. So if you've overstayed for more than 180 days, you're subject to a 3-year bar, or if you've overstayed for more than a year, you're subject to a 10-year bar. So in that situation, you could file for I-601 waiver if you're outside the United States, or an I-601A waiver if you are in the United States. So neither one of those situations. The I-601A waiver is nice because you get to apply while you're in the United States, whereas the I-601 waiver, you're applying for outside the country. So for the I-601A waiver and the I-601 waiver, you have to demonstrate extreme hardship. And you might be wondering, well, what is extreme hardship? Well, extreme hardship, that's to the qualifying relative. So that could be for the I-601 waiver or a 601A, your U.S. citizen or lawful permanent resident spouse, or U.S. citizen or lawful permanent resident parent. Now don't confuse that with the J1 waiver. J1 waiver, parents are not qualifying relatives for the hardship waiver. However, children are, but that's specific to the J1 waiver. Right now, we're talking about the I-601 waiver and the I-601A waiver. So some different types of hardship are career hardship, not having the ability to have your career outside the country, financial hardship, health hardship, mental health hardship. And what we do in our cases is really create the narrative of how these hardships are going to affect your U.S. citizen spouse or qualifying relative, explaining it based off of the information that you provide to us in our legal brief, what could happen and how this hardship would occur. And this is extremely important because it's a paper filing, and paper filings are good and bad. The good is that you get to provide all of your documentation and submit everything, and it's not up to how you perform in an interview. However, you don't get to explain yourself at an interview that sometimes could rectify some adequacies in the paper filing. Another question is, can you apply for a J1 waiver and a national interest waiver at the same time? Well, it really depends on, this is a complicated question because it depends upon your unique situation. So it depends on the timing, how much longer you have left on whatever visa that you're on. One important thing to note is that you can file for the national interest waiver and the J1 waiver, but there's a lot of timing considerations because the J1, for instance, the J1 hardship waiver, which many of you are applying for, taking around 2 years, and the national interest waiver, you have the I-140 process that is filed initially, and then you have the 45, but you can't go on to the 485 until the J1 waiver is approved. So the other important consideration is that J1 waivers are very difficult waivers to get approved. So you may want to consider getting a decision on your J1 waiver before applying for the national interest waiver. And this is something that you should really discuss these issues with your attorney depending upon your unique situation. But you can apply for both at the same time, but you can't file for the 45. Another question is, what is a national interest waiver? Well, the benefit for the national interest waiver is that it overcomes, or you get to bypass the labor certification requirement. So in a typical employment-based green card application, first of all, you have to have an employer sponsor. National interest waiver, you don't. And then you have to, in a typical green card employment-based application, there's the labor certification process. And that's to test the labor market to see if there's any qualified U.S. workers for the position. Now, the national interest waiver skips over that whole process. And the other big benefits is you don't need to have an employer, but you need to show that what you're doing is in the national interest and that you have the expertise to move whatever you're doing in the national interest to move that project forward. All right, well, if we don't have any other questions, then we will call it a wrap. We will be here next week at 12:30. Go ahead and feel free to send your questions ahead of time, and that way we can make sure we get them answered as well. So thank you, everyone, and until next week, bye.